Many caretaker contracts have a vague scope of works. They may say the driveway should be cleaned once a week, but there's no reference to the standard. This can lead to disputes over the quality of work being done. How should committees approach conversations like this with caretakers? What's a good response if the caretaker says that's not in my contract?
Well, it's a great question from Will, Nikki, and one that we field a lot of because the common themes that we see in caretaking agreements is that the older the agreement, the more vague, the more broad, ambiguous the terms are, or the duties are. The more modern agreements have what we call a specified duties list. And that specified duties list really does give the prerequisite particularisation, but also frequencies built in there. Now, I guess to answer Will's question, how can a committee approach these type of conversations? It will depend on whether they've been approached previously with the caretaker. If they have been approached and the caretaker has essentially responded with, that's not included in my contract, I'm not going to be doing that, the next step for the committee to consider would be to get an independent management rights expert into the scheme and to do what's called a common property condition report. I think it's safe to say that most committee members would not have the prerequisite skill or knowledge as a management rights expert would do. And the difficulty we see is that there is always this argument of nitpicking. The caretaker says the committee's nitpicking, they're being subjective in how they're scrutinising our performance. And then the committee says, no, we just want it to be of the standard that we expect. So having a management rights expert come in there and do a common property condition report, it takes away that subjectivity. It takes away that argument of nitpicking, and the committee can say, okay, it's not us that is scrutinising you. We've got somebody independent in. This has been the report about the standard of the scheme and the condition of the common property. Can we table it and have a discussion with you about how we can go about fixing this? There's two very different interpretations of your duties, and unless we work together to resolve them, we're going to continue to have these arguments about what you are or are not required to do. Now, depending on how those discussions go, if they go poorly, the committee might need to consider issuing a remedial action notice. But if they go well, the committee might engage in some private negotiations with the caretaker to say, okay, let's tidy this up. We don't agree. Let's get a specific schedule of duties prepared by an expert that ultimately says what you're required to do with a good satisfactory level of particularisation and the frequency in which you're required to do it. And let's do a deed of variation, put it to owners so that we can resolve this moving forward. That, to me, would be a pragmatic commercial outcome for both parties. It's all about how you communicate it, and it's all about making sure that what starts as a performance-based issue doesn't escalate into a personality-based issue because of poor communication there as well. So that's probably how I would deal with it first and foremost. And obviously, my opinion with specific schedules of duties is they work for both parties' sides, because the caretaker then knows what he, she, it is required to do, and the committee knows what is required, and there's an ability to check things off and not have different interpretations of things as well.